Hello, this is Josh Belk with the Belk on Business podcast. Thank you for taking a few moments to listen in today. We have a very special guest with us, and it's in a world that we get a lot of questions on, and that is in regards to trust. And specifically, we're going to talk today about land trust. For a lot of our clients at the firm level, we have a lot of our clients that are in real estate. And we kind of met, Joe and I met through a kind of a mutual connection, and I thought it would be just a wonderful opportunity to bring someone on to talk about this somewhat, I think, maybe a little bit confusing, maybe a lot confusing for some people as it relates to land trust. But before we kind of get in there, let me kind of just introduce our guest, and then we'll just kind of hop right into this. So, Attorney Joe Seagle, he's a refers to himself as a legal GPS. I like that; it's kind of cool. A legal GPS for real estate investors and high net worth individuals. Mr. Seagle's law firm and land trust company supports real estate investors, developers, brokers, property managers, and private lenders on their land trust, private lending, and entity formation needs. Practicing law since 1996, he is licensed in Florida, North Carolina, South Carolina, and the District of Columbia. He's also a licensed Florida title insurance agent. And you can find more information regarding Attorney Seagle Land Trust at his website, mylandtrustee.com, mylandtrustee.com. No, we're going to talk about land trust today, which will be a lot of fun to talk about. But I noticed you had in here about being a Florida title insurance agent, and we have a number of clients in Florida, and I understand that you have to do attorneys, not title companies down there. So I know it's kind of probably definitely a value add for your clients. So, Joe, before we kind of hop into this, if you can kind of just give us, and you've probably been in rooms, I know I have as well, and we get questions from clients as far as putting assets into a trust, and you kind of just hear this word trust thrown around, and many times people use those terms and not necessarily have an exact real good understanding as far as what is a trust and when are they most helpful. You can kind of give us just a little bit of idea or kind of an overview on that, just kind of on trust in general.
Yeah, that's a good question. Trust in general, a lot of people, when they hear the word trust, they think of probate trust, for your assets to pass outside of probate so it doesn't go through court when you die. In that case, typically you will put everything into the trust and you will be the trustee, so your name still appears on everything. But when you die, and you'll be the beneficiary of the trust, meaning you control the trust, you are the trustee, and you are the beneficiary, all rolled into one. But when you die, then the trust instrument speaks. It tells everyone what to do with all of those assets that you had put into this trust during your lifetime. And the new trustee will take over, a successor trustee will take over upon your death, and that person will be charged with following the terms of the trust agreement that went into effect when you died. And they will then sell the property, give the property to whomever's supposed to receive it, reduce it to cash. They'll do what they need to do with that property as you directed before you died. And that's what most people think of when they hear trust. Of course, there are other trusts. There are business trusts. There are irrevocable trusts. There are offshore trusts. What we do are land trusts. And Florida, Illinois, Indiana, Hawaii, I believe in at least one other state, they have statutes or they have case law that particularly authorize these types of trusts to exist. And in Florida, the land trust is used to for a third party to act as your trustee, usually, so that no one sees your name as the owner of the property. Now, you may still be the beneficiary. Typically, you are still the beneficiary of the trust, and you're the one telling the trustee what to do with the property. But your name, your identity never appears anywhere. And if everything's done properly, never will appear anywhere. It will be that trustee, us. Our name will be on everything, lawsuits, leases, contracts, permit applications. Everything will be signed by us. So tenants, buyers, sellers, lenders, all these people may never know who the beneficiaries are because they don't need to know. There's no reason for them to care because the trustee has full authority to do anything with that property they need to do, and no third party dealing with that trustee ever has to actually read the trust to make sure that the trustee has the power to do what they're doing. So those are the biggest differences I think that most people would see between those two types of trust.
So a land trust, and correct me if I'm wrong, it's a grantor-based trust, right? Like a living trust, that type of thing.
They are revocable.
Okay.
The beneficiaries can revoke them. Actually, the trustee can resign at any time that they want, and the beneficiaries can remove the trustee if they want and change it to a new successor trustee. And it's usually just filing a piece of paper. So they are grantor trust. One big difference is passive trust versus active trust. Under the revocable trust or the irrevocable trust that most people think of for their estate plan, that's called an active trust, which means the trustee has a duty to make that property productive and to also do something. They have activities that they are required to do, whether it's paying tax bills, protecting the property, buying property insurance, choosing tenants. They have some duty with the property that they have to exercise their discretion with. In a land trust, it's considered a passive trust, which in most states you can't have a passive trust, or they're also called dry trusts, because the trustee has no authority to do anything in a land trust without the beneficiary telling them, do X, do Y. So before we sign anything, before we do anything, we typically get an email from our beneficiaries telling us, sign this, do this, send this money here, get this money from there. But we have no discretion other than our discretion is we won't do anything illegal. We won't do anything illegal for the property. We won't engage in fraud or anything like that. But our recourse is to just resign as trustee, and that's about it. So we are very passive, very dry trust, but under the statute in Florida, which I sat on the committee that actually for the Florida Bar that helped write the last two revisions of that statute. We made it very, very clear that land trusts are perfectly allowed to be passive and dry, and they are still in existence and still have authority to do what they need to do, regardless of that fact.
And does the land trust actually need to be set up in the state that the property is physically in?
They typically are governed by the law of the state where they are set up. Now, we do have people who do land trusts in Texas and Georgia and North Carolina and South Carolina. We're just not the trustee of those trusts at this time. We're only trustee of trusts inside of Florida right now. Whenever they go into those other states, because there is no statute, because there is no case law, we typically shy away from that. Because we're concerned that at some point, since I do practice in North and South Carolina as well, and handling closings up there for years, we know that regardless of what the deed says or the trust says, we have a duty when we're doing a closing in those states that we must look at the trust agreement itself, read it, determine who the beneficiaries are. And if we see that that trust is a dry trust or a passive trust, we have to get the beneficiaries to also sign the deed. So now their name is out there. So that's a danger you run into whenever you use a land trust outside of a state that has a statute or the case law. In the case of Illinois, it's case law that allows the structure to exist as it does.
Understood. Okay. And now, so land trust, so it's primarily you're putting real property into the trust. What about your own personal homestead? Should someone put their own house into a land trust?
That's a really good question. One I get a lot. If you had asked me that question last year, I would have said, in Florida especially, that Florida has such a strong constitutional homestead protection that we don't want to take a chance of ever losing that. So let's just keep the property solely in your name, and it's going to be protected against your creditors and all these other things. But you don't have anonymity. Everybody knows where you live, unless you're one of the exempt parties, like a judge or a doctor or a nurse, a policeman, fireman, who can hide that from the public record. But since April, we merged with another land trustee who it was very common that they would put homestead properties in there. into the land trust. So you can do it. You can put it in as long as there's special language on the deed and in the trust. So a lot of times we'll amend the trust to include this special language that says that the beneficiary reserves the right to reside in the property during their natural life. And in Florida, that's sufficient to still get your homestead exemptions and protections even inside of a land trust. So we do it. I still, worry about it to a small extent, but it can be done. One thing that we always are also concerned about in the state of Florida is anytime you change title, the tax appraiser can reappraise your property. So they remove all caps, they remove all exemptions, and reappraise at new current market value. So you may have owned a property for many years and your tax valuation is $100,000 less than the actual market valuation. So you're not paying tax on $100,000 of value. But as soon as you change title, you always run the risk that the property appraiser will go, now we're going to add that 100,000 in. We're going to start taxing you on that. And so that's part of my advice whenever I meet with clients is to consider that, how long they've owned it, look at the market value versus the taxable value, and weigh that with the benefits that they'll get from the anonymity of holding the property in trust.
I know up here in Indiana, it's been an issue when because of that, the homestead exemption. Then also they have different percentages for homestead properties, and as far as caps,
Right.
as far as homestead properties and investment properties. And what we've seen is that, yeah, the state wants to come back and go from the 2% exemption to the 3, increase that, as well as the actual floor for the exemption itself. So,
Right.
So it's kind of one of those things. It sounds like you really need, if you're going to go this direction, you're going to have to kind of weigh the pros and the cons, and kind of look at what your state allows, and then take it from there. So
Right.
now, so we talk about homestead now. Now we talk about investment properties, which is usually where, from my experience, what we've seen land trusts use primarily as single-family residences get put into these. But our land trust, are they used for all types of investment properties, from land to commercial? Is it is it ideal to use those in all of these situations? Only a few of them?
Actually, yeah, we probably we've done our analysis. About 50% of what we hold is residential, and the other 50% breaks down into vacant land, industrial, commercial property. Based on valuation, however, probably 75% of what we hold as far as value goes is industrial and commercial, because they're just worth so much more. We have one property we hold in trust that's worth over 50 million. I know this week we took into trust, just since Wednesday, about $8 million of worth of property between Wednesday and Friday last week. So we do hold a lot of very high value commercial properties out there. And typically, if you're not going to live in the property, if you have tenants, if it is industrial, if it is commercial property, the land trust is a nice way to do it, because the real name doesn't appear there. It also gives you the benefit, if you don't want to do a JV agreement, you don't want to have a partnership hanging out there, then you put it in a land trust, and you have the investors who came together to buy this commercial property are all the beneficiaries in their percentage interest inside of the land trust, rather than through an LLC or a corporation, if anyone would still hold real estate in a corporation.
That's really interesting from a structural component, which you kind of touched on there. So instead of getting into a specific JV agreement, or setting up a separate entity to utilize a land trust, as far as from a structural end for a particular piece of property or a particular investment. So now, when it comes to land trust, and I've heard, you kind of hear this feedback, and a lot of times it's from, well, I heard this, as it relates to land trust? Are they primarily an asset protection tool, an estate planning tool? Is it just used for anonymity? They kind of touch on all three of those. If you can kind of touch on that.
It's sort of all three. We have a lot of people who want it for the anonymity. I have one man that he has 27 houses that he owns, and he wanted the anonymity because he said if my family, my cousins ever found out I own 27 houses, they would think I was rich and they would come and ask for money all the time. So, there's that component. Others, they may own multiple properties in the same county, and they want the asset protection in that it separates the properties from each other. So each property is in its own land trust, its own little basket, while also being separated away from them as the owner. And so that provides them that level. Control, whenever they're dealing with tenants, they can say, hey, I'm just here. I'm a manager for the trustee who owns the property, and the rent's going up, and it's going up, 20%. I'm sorry. And the tenant, negotiates with them. They don't realize they're negotiating probably with the beneficiary of the trust, who really has this say, but they can play us as bad cop while they're the good cop. And it helps with the negotiation a little bit. So different people use them for different reasons. Estate planning is also a part of it. We can, inside of the land trust, build out the ability to pass it down. So you hold the beneficial interest for and during the term of your natural life. And then upon your death, it will go to the next level down. We can't get into the details of going deeper and deeper down into that, into those estate planning levels. And we typically will suggest to someone that if they are wanting to go, well, I want it for my life, and then I want it to go to my kids, but if my kids die first, I want it to go to my grandkids. But if a grandchild has died before the other grandchild, I want it to go to the other grandchild. If they get into that, we go, you need a revocable living trust first. So get that together. And then your revocable living trust will be the beneficiary of the land trusts, each land trust you have, so that when they die, we just answer to the successor trustee of their revocable living trust to tell us what to do with the property as the trustee. But in the meantime, no one knows who really owned that property, how much they got for it, or how much they're going to sell it for. So no one knows what their estate was really worth, which goes back to the anonymity to a large extent.
So in order for this to work, we've had clients that bought a property in their entity, for example, an investment property into their entity, and then they put it into a land trust, which seems like that would kind of defeat the purpose as far as from an anonymity end a little bit, simply for the fact that they didn't close the property. So ideally, when you're going, and regardless if this is for your homestead, investment property, whatever the case may be, when you actually go and purchase the property, it needs to go into it actually does need to go into the land trust at the point of closing, correct?
That's absolutely the best practice if you can do it. Some title companies or attorneys, closing attorneys, don't understand it and just won't do it. Sometimes your seller won't cooperate. In Florida, one of the things that we can do, and we actually use it as a selling point for the seller, is to say, hey, how about this? You're going to sell it, and it's going to go into the land trust, and you're going to be the beneficiary initially. And 2 seconds later, you're going to sign an assignment of beneficial interest to the end buyer as the beneficiary of the trust. And we're going to pay the documentary stamp taxes directly to the Department of Revenue on that assignment of beneficial interest. We're not going to pay it to the clerk of court where your deed is recorded. So the amount you received for selling this house will not appear on the public record. No one publicly will know what you sold this property for. It'll go straight to the Department of Revenue. So that's actually a selling point for sellers to use the land trust. And the buyers, of course, are happy because now the property went straight into the land trust from the very first second. So their name never appeared on the public record at all. And that's absolutely the best case scenario. Sometimes you can't get the closing company or the seller to cooperate. So you end up just closing into your name, and then a day or two later, as soon as it's recorded, we'll record the deed out of you and in to us as trustee. Typically, it's been our experience that plaintiffs' attorneys don't really do title searches to see everything you ever owned. They just look at what you own right now whenever they're getting ready to file suit to determine if you're judgment proof or not. And if they see that you own a lot of property, now, and judgment proof means they can't collect from you. So if, let's say you're in a contractual dispute with someone, so there's no insurance that covers a breach of contract. So you've breached a copier contract, for instance, and it was a big copier, you owe $100,000 on this contract and you just can't make it anymore. So you walk away. It's the only debt you have. It's not really worth going bankrupt over. And you personally guaranteed it. When that copier company hires a lawyer to go sue you, they're going to negotiate, but they're going to search too to see what you own. And if they see that you don't own any real property, they're probably going to go, hey, let's just negotiate. If we can get a couple $1,000s out of this person, we're going to be doing well. Let's get the couple $1,000s and move on. They don't know about the 27 pieces of real estate you own. They don't know about that warehouse that you own somewhere because it just doesn't show up on the public records. All they see is your name and you don't have anything. And now you've breached $100,000 contract that they'll never collect anything. So why are they going to spin their wheels and time and effort and energy and money to go after you for nothing?
If an individual is getting, either them or their entity is getting sued, the property is in a land trust, the plaintiff's attorney asks the question, do you or your entities own investment property? So in the process of discovery, say, for example, so they ask that question. How does the individual answer that particular question? Do they have to disclose that information at that point?
They would have to say, well, because they would ask, what do you own in any form or fashion? Usually that's presupposing that they've actually filed the lawsuit and they're moving forward with it, that they've figured you have something to get to make it worthwhile. What we've found, though, is those questions don't come up because they never sued them in the first place because they look judgment proof. So they didn't bother suing them. Where it really comes up is someone has sued you and they're in what's called post-judgment collection. Now they've got your tax returns. They're going to find everything you own when they get you. If you've been honest with the IRS on your tax returns, they're going to find everything you really have. Mm-hmm. They're going to have bank accounts. But what we try to do is go, well, in our perfect world, they've looked at you and you look like you don't have anything. So they're not even going to bother really suing you and going very deep into this because, and I've sued people, I've been sued, and I know what it's like. And one of the things you always do is you go, well, is this person collectible that we're getting ready to sue? Is it worthwhile to spend $50,000 to $100,000 worth of attorney's fees and court costs and discovery going after this person who on paper and on the internet looks like they have nothing? So you're just going to throw good money after bad. So as an attorney, back when I did litigation, I would have looked at them and I would go to my client and go, okay, this is going to cost you $50,000 to $100,000. It's going to take 2 years. And when we get to the end of it, they have nothing. And you're going to be very angry at me because I just spent a lot of your time and money and energy to get nothing for you. So we would actually have clients sign off before we would even file that suit, saying they understood it and they held us harmless for going ahead with the suit. So that's really why the anonymity is so important, is because you don't want to look like a target out there.
So it sounds like for the most part, it's going to eliminate or help eliminate a lot of the nuisance, what I call nuisance suits, kind of that type of thing, especially if you have tenants, that type of thing. Because it seems like, you have it in a land trust, you're using a property manager that's separate from you, that type of thing. They have no idea who owns the property. All they know is their property manager. They go and look it up. They're not going to find who owns the property. And so they have a kind of a minor type of thing. They go and sue. The attorneys can look at them and, right, probably advise them not to go down that road.
Yeah.
Okay.
The worst cases, the worst cases we always have, it's physicians who own duplexes and little apartments and little houses that they rent out. and their name is out there, and the tenant goes and Google searches them and finds out that, hey, she's a cardiologist, she lives in a big gated community, she's got lots of money. I think I'm going to make a fair housing violation claim against her. I'll go get a lawyer who does a fair housing claim against this doctor. And so we hold a lot of professionals like that. We hold a lot of their properties as well, so their name doesn't appear.
Good deal. Tax implications. Obviously, you're not a tax attorney, that type of thing. But are any sort of tax implications? You go and you move a property into a land trust.
There should not be. The land trust, as far as the service is concerned, is completely a disregarded entity. It does not exist. We do have to file what's called Form 56 with the IRS to let them know that we are, and any land trustee has to do this, to let them know that you are the fiduciary for the beneficiary. But that's it. You file that so that they can connect the two together. But everything passes through on the beneficiary's tax returns directly, without any problem at all. So for that reason, we actually have a lot of people will use land trusts in a 1031 exchange situation, where maybe they held a property in an LLC in New York, and now they're buying a property in Florida, but they don't want to have to register that LLC to do business in Florida. So they'll go ahead and say, fine, we'll set up a land trust in Florida. We'll be the owner of this property. Will exchange out of the property in New York, buy the property in Florida. Inside of the land trust, the same LLC is the beneficiary of the land trust for pass-through taxation. And as far as the service is concerned, the tax ID matches New York and Florida. So they're good. They're happy.
Okay. I think two follow-up questions. One in regards, can someone just sue a land trust? So we end up with this tenant, whatever the case may be, they go and they look and they see that there's a land trust number 4126 owns this particular property. Are they able to just go and just sue the land trust?
Absolutely. We get sued at least once a week, sometimes 2 or 3 times a week. And it's typically someone has been injured on the property and they're trying to get to the insurance. So we do, of course, advise beneficiaries that they should carry liability insurance on the property. It's just smart. Most of our clients carry anything from $100,000 to over $1 million worth of liability insurance. And it's a business risk premises liability, business owners premises liability policy that they carry. And it names the trust as well as the beneficiaries as insureds. So if anything like that does happen, of course, the insurance company steps in to tender defense to handle it. Then also we have, of course, contractual disputes, sometimes family disputes over the property. And we are named, we're served, we immediately scan it and send it off to the beneficiaries to let them know that they have been that the trust has been sued, so that they can hire counsel and deal with that.
So so an entity owns so let's talk about out-of-state issues. So an individual, they live in the state of New Jersey, they happen to buy a property that's in Florida. They don't set up as an investment property. They don't set up an LLC or another type of an entity inside in Florida. They just want to put the property directly into a land trust. What happens when they want to go and pull permits, whatever the case may be, and the question gets asked in regards to registration in the state? Does the land trust document itself, is that sufficient in order to be able to pull permits and do that type of thing in the state?
Yeah, we sign, I probably sign 20 permit applications and notices of commencement a week. It's very common. And so we sign the contract with the contractor, we sign the permit applications, we sign the notices of commencement, and no city or county has ever had a problem with that. Sometimes they do ask to prove, well, how does Joe Seagle have authorization to be signing this? And we go, well, here's the deed. Here's the company that's the trustee. Here's the SunBiz listing. And there's Joe's name. Are we good? And they go, oh, okay. Most cities and counties now, we're in, there are 67 counties in Florida. I believe we are in 62 of them. We own properties in 62 of them. And the ones where we're heaviest in Central Florida, South Florida, North Florida, they really know us already. So as soon as they see our names come across, they know who we are and they don't worry about it.
Good deal. Just to kind of transition a little bit, talking about an LLC versus a land trust, or using them in conjunction. So what protection would an LLC provide over a land trust, and vice versa? Is it better to have an LLC? Is it better just use a land trust? Or if I have investment properties, it's best to have an LLC and then have that LLC as the grantor / beneficiary of that particular land trust? How would you advise in that area?
That's a really good question. I take those on case by case. I would talk to the client, and typically there are two things I'm looking at. Do you want control or do you want anonymity? And for very, very large, complex commercial properties, often I will recommend, like a multifamily apartment complex, I would recommend an LLC rather than a land trust for a couple of reasons. Number one, Fannie Mae, Freddie Mac, if you're ever going to do a multifamily refinance, they'll lend to an LLC all day long. But when it's in a land trust, they sort of freak out. So that would be one of the factors I consider. Control of dealing with the day-to-day operations. Now, a lot of times you may have a property manager who's going to deal with that anyway, and they're going to be signing the contracts, the leases, and everything else. So that's not an issue. But if you're self-managed, a lot of times you want to just be able to sign the lease, sign the eviction papers, sign whatever needs to be signed really quick and move on without having to send it to a trustee, have us sign it and send it back, which usually we're done within the same business day or the next business day at the latest. And a lot of times over the weekend, I sign a lot of things as well. So it's control versus anonymity. And then financing comes into play. Fannie Mae, Freddie Mac, conventional versus non-conventional. All of those things come into play as to whether one works better than the other. One issue that I do look at is later, if you are going to be transferring this property to another entity or another person, if it's in the name of the LLC, if you transfer it and it has a mortgage on it, that is considered a taxable event, and you have to pay the mortgage stamps again in Florida on your outstanding mortgage. And if you've got a $5,000 mortgage, a $5 million mortgage on the property and need to transfer it from one LLC to another, that can be very expensive. Whereas if it's maybe in the LLC or in the land trust and you need to convey it in or out to that same entity, that's a non-taxable event regardless of any mortgages on the property. It's specifically exempted under the administrative code in Florida. So these are all things that I take on a case-by-case basis and talking with the client. But I did recently, we actually took a property out of a trust for a client who was refinancing from a private loan on a 32-unit apartment complex into a Fannie Mae backed conventional loan on the same complex. We deeded it out of the trust into the LLC that was the beneficiary of the trust, just so Fannie Mae could get the loan done quickly. Because if they'd had to do underwriting on the trust, it was going to add about a month to the underwriting.
Let's take the next step, due on sale clauses. So this is another area that I think somewhat related to what you were just talking about. So moving a property in and out or outside of that particular land trust, could that pull the trigger on a due on sale clause in the mortgage contract?
It could, depending on the property. If it's your homestead, you're allowed to move your primary residence in and out of trust, land trust, revocable living trust, whatever, for estate planning purposes. And it does not trigger the due on sale clause. That's under the Garn-St. Germain Depository Act. That's okay. But a lot of people miss that, what I just said there, your primary residence, because that's what that applies to. A lot of people think it applies to everything, but it doesn't. So if you're moving investment properties in and out, there's always a chance that a lender could call the loan due. And we've been doing this, I've been doing it since 2004 and well, actually 2002. And prior to that, the company we acquired had been doing it since the 1980s. And in all that time, we've had it happen twice. It was Flagstar Bank both times, called a loan due on our same, it was the same beneficiary, had moved two different properties that were subject to Flagstar mortgages into a land trust with us. And they saw the insurance had changed and the tax bill had changed the name to an LLC as trustee of a land trust. So it freaked out Flagstar, and Flagstar called the loans due, gave them 30 days to either pay the loan off or get the property back. We fought the first time for about 5 years. We just argued with them until finally they realized that it was the same person, and they said, "Oh, don't worry about it." And then they did it on the second loan that they had with them. They caught it, a different person in the company caught it and did the same thing. And finally, our client said, "I'm just tired of dealing with this. So just go ahead and put it back in my name, and I'll hold these solely in my name." She wasn't happy about that, but it wasn't our fault. That was Flagstar. So a lot of times it's just going back and forth. But again, most lenders are not looking at that. As long as taxes are being paid, the property's insured, and they're getting paid on their note, they're not going to bother you. We are concerned now with interest rates going up so quickly that a lot of banks will look at this as a way of getting mortgages off their books. And so they could be culling and going through looking for properties where the name of the borrower does not match the name on the tax records or the name on the insurance policy, and using that to cull all of these loans off their books so that they can get some more capital in. But that's going to take a lot of labor and energy and effort, and the payoff for the lenders, I don't know if it'll be worth it for them to bother doing that. So we haven't seen it happen yet. Don't know if it'll ever happen, but it is always a danger out there.
So it sounds like probably the moral to the story, so to speak, is to make sure that if you're going to go this route, to utilize the land trust on the front end, so everybody's on the same page. If you do end up needing to move so it's in a land trust, you end up needing to move it, to go the route of essentially an assignment to change essentially the beneficiary of that particular trust, maybe from one LLC to another. Are there any issues by doing that?
If there is in Florida, if there's a mortgage outstanding, anytime you change the beneficiary, that's considered a sale of the property that's subject to documentary tax again. So yeah, we would have to, and that's a big question. It often comes up because we get that call all the time of, "Hey, I would need to change the beneficiary from this to that." And we're always asking, is there a mortgage on the property? Because if there's a mortgage, there's going to be documentary tax. If there's this or that, we have to consider this, and we let the client know this could be an issue for them. And sometimes, they brought the property in to the land trust. They bought it, and they put a mortgage on it, and the land trustee signed the mortgage to put the lien on the property for the bank. And we'll look back through our records, and they want to change the beneficiary, and we have to tell them we can't have any part of that, because we actually, as trustees, signed a separate agreement with the bank at the time of the closing that we will not allow a change in the beneficiary without notifying the bank. So if you're okay with us letting the bank know, we'll do it, but otherwise we can't. But that's very rare. That's if the bank gave the loan to the land trust at the time of the closing, and that's less than 1% of our commercial closings that we have out there.
So it sounds like just make sure there's plenty of proper planning before going down this road. So there's a huge upside. Understand there are some potential pitfalls, to make sure that all those are addressed before you go down this road. So right. Attorney Seagle, I appreciate the time you spent. One last question, and then we can go ahead and wrap this up. And let's talk about something happens. Okay, so we're at the point, either essentially the beneficiary of the land trust, they pass away, or it's inside of a business. The business dissolves, goes defunct, whatever the case may be. What happens in that situation?
It happens, of course. I mean, beneficiaries die. If they did not have successor beneficiaries named inside of the trust agreement or inside of an assignment of beneficial interest that we had prepared for them at some point, then we just ask them, who's the PR of the estate? Who's the personal representative? Who's the executor or administrator, whatever you want to call them? Who is it? And then we talk with those folks and we let them know, hey, this is like a bank account. This is an asset of the estate. So you will need to list it. And we answer to you. You tell us what to do and what the court lets you do. We will do that. Going back to your New Jersey, Florida scenario, this happens quite often. Let's say you do live in New Jersey, you buy property in Florida solely in your name. If you die in New Jersey, you will have to open a probate in New Jersey to deal with everything in New Jersey. But Florida, when it comes to real estate, Florida is the only state I know of that gives no full faith and credit to any other state's orders, no other court in any other state telling the state of Florida what to do with that piece of real estate. So you would have to open another, what's called an ancillary probate here in Florida, which costs more money for the estate and usually significantly more money and time before you can ever sell that property here in Florida or do whatever you want to do with that property here in Florida. You have to open up another estate down here, hire a lawyer down here because unlike a lot of other states, you are required to have an attorney to handle the probate. A layman is not allowed, a non-lawyer is not allowed to handle a probate in the state of Florida because it's the same as representing a corporation or an entity. You can't do it. But if you had bought that property here in Florida inside of a land trust, then we just do whatever the executor or the PR up in New Jersey tells us to do with the property here in Florida, because we will give full faith and credit to whatever that judge up there is doing, because your interest inside the trust is personal property. It's not real estate. So the PR just simply tells us, hey, according to the will, you need to sell that property. So we're just going to put it up for sale. We're going to sell it, reduce it to cash, and you're going to send the cash to the estate of so-and-so, and we're done. You don't have to open the estate. It's not going to take you anywhere from 6 months to a year to do anything with that property. It's just handled.
So do you generally advise your clients to make sure they have successor trustees when they set these land trusts up?
Successor trustees and successor beneficiaries, at least one level, the one level of beneficiary is nice, because then it just automatically goes. The one caveat to that is if your beneficiaries are minors, if you've got minor children under 18, you really need to have a revocable living trust anyway. You need to have a full-blown estate plan set up. That's full stop. You need to have that if you have children under 18. And with that, then you make that trust your beneficiary of the land trust, and it just sells through. Makes life a lot easier.
All right, before we exit, I want to give you an opportunity. I know we talked a lot about land trust. Tell us a little bit, maybe more about yourself, maybe other areas you can provide help to clients.
Yeah, I don't do litigation. I don't do landlord-tenant litigation. I don't do anything like that. We do transactions, real estate transactions, mostly in Florida, but also a little bit in South Carolina and North Carolina. And we do deeds for a lot of estate planning attorneys, deeds for properties in Texas, Florida, Georgia, North Carolina, South Carolina, Tennessee, Virginia, Maryland, and DC, because we have lawyers licensed in all those states. So anything transactional related. In Florida, of course, we specialize or focus on land trusts. That's really big. We do have My Land Trustee, which is our separate ancillary business out there, because law firms are not allowed to act as trustees of land trusts because it is beyond the practice of law. So it's an ultra vires activity. They get us on that. So that's why we have a separate entity that acts as the trustee. And another thing I do is I do a lot of LLC work. I do set up a lot of LLCs. And as a subcategory of that, one of the things we do are self-directed IRA LLCs. We set up a lot of those in Florida as well. So if you have a self-directed IRA and you want to have it a checkbook control, we can set that LLC up with the operating agreement that's required that meets the IRS guidelines for those as well. So
That is
and we
wonderful to
represent
know.
a lot of buyers and sellers and lenders in any kind of real estate transaction in Florida.
Okay. I have a feeling people are going to listen to this with a land trust, but the last thing you said in regards to the self-directeds, we're constantly getting questions on that as far as what helps in that area as well. So thanks for sharing. Attorney Seagle, Joe, appreciate you coming on today, spending a few moments with our audience, and we'll get this out here in the next couple of days. And once again, I appreciate you being on. This is Josh Belk with the Belk Business Podcast. Thank you for taking a few moments to listen in today. Please, if you haven't subscribed, please consider subscribing. Have a wonderful day.